Humans have always been concerned about their safety. Prior to the industrial age, natural disasters provided the biggest challenge. Things started to change in the early part of the Industrial Revolution in Europe and the United States. Workers in factories were considered expendable and were often treated worse than slaves. Slaves cost a great deal of money, and owners wanted to protect their investment, but workers cost nothing to hire or replace. The prevailing attitude was that when people accepted employment, they also accepted the risks involved in the job and should be smart enough to avoid danger. At the same time, factories were filled with potentially dangerous equipment, such as unguarded machines, flying shuttles, and open belt drives, as well as unsafe conditions, such as open holes. There were no fire escapes, and the lighting was inadequate. Hardly a day went by in most countries without some worker being maimed or killed without workers' compensation laws. Employees in the Western world had to sue and collect damages for injuries under common law. In the United States, the employer almost could not lose because common law precedents established that an employer did not have to pay injured employees if 1. The employee contributed at all to the cause of the accident. Contributory negligence held that if the employee was responsible or even partly responsible for an accident, the employer was not liable. 2. Another employee contributed to the accident. The fellow servant doctrine held that an employer was not responsible if an employee's injury resulted from the negligence of a co-worker. 3. The employee knew of the hazards involved in the accident before the injury and still agreed to work in the conditions for pay. The assumption of risk doctrine held that an injured employee presumably knew of and accepted the risks associated with the job before accepting the position. It is not therefore surprising that most investigations of accidents which were conducted by management found that the workers were responsible. The horrific workplace conditions existing at this time led to social revolts by activists and union leaders. Miners, railroad workers, and others became concerned about the hazards of their jobs and began to agitate for better conditions. Voluntary safety organizations, such as the American Public Health Association, the National Fire Protection Association, and Underwriters Laboratories, were formed in the late 19th century and were active in setting standards. The first efforts focused on health rather than safety. Accidents were seen as fortuitous events over which we had little control. Concern over worker safety started in Europe. Otto von Bismarck established workers' compensation and security insurance, paid for by the employees in Germany during the 1880s. Bismarck sought to undercut the socialists by demonstrating to the German working class that its government was in favor of social reform. Soon, most countries in Europe followed Bismarck's lead. Other types of safety legislation were also passed in Europe. For example, the Factory and Workshop Act of 1844 in Great Britain was the first legislation for protection from accidents involving shafts, belts, pulleys, and gears used to transmit power from a water wheel or a stationary steam engine throughout the factory. Later, laws setting standards for equipment such as high-pressure steam engines and high-voltage electrical devices were enacted. The textile industry was one of the first to become mechanized and also contributed more than its share of injuries to workers. The abuses in the mills led to protective legislation and codes in many countries by the end of the 19th century. The same was true for industries that employed metal and woodworking machines. Unfortunately, many safety devices, added only grudgingly, were poorly designed or ineffective. In the United States, employers remained indifferent to the many workers being killed and maimed on the job. Eventually, social revolt and agitation by unions against poor working conditions led to social reforms and government intervention to protect employees and the public. Individual state laws preceded federal legislation. The first successful regulatory legislation in the United States was enacted in 1852 when Congress passed a law to regulate steamboat boilers. This law resulted from public pressure enhanced by a series of marine disasters that had killed thousands of people. In 1908, the state of New York passed the first workers' compensation law, which in effect required management to pay for injuries that occurred on the job, regardless of fault. The New York law was held to be unconstitutional, but a comparable law passed in Wisconsin in 1911 withstood judicial scrutiny. All other US states and many other countries have now enacted similar laws. The last was in 1947. When management found that it had to pay for injuries on the job, effort was put into preventing such injuries, and the organized industrial safety movement was born. Owners and managers also began to realize that accidents cost money in terms of lower productivity and started to take safety seriously. The first industrial safety department in a company was established in the early 1900s. The heavy industries, such as steel, in which workplace accidents occurred frequently, began to set safety standards. This legal history provided an important impetus to technical developments. So now let's examine the historical narrative from a technical viewpoint.